Okay, we're still in Article 120, warrant of arrest. This is 120.10 and 120.20, and then we're going to do 120.30. Let's knock it out. These are quick keyword cards. Okay, so 120.10, warrant of arrest, definition, function, forms, and content. So lower criminal court is going to direct the police officer to arrest upon the accusatory instrument that was filed for arraignment, the defendant, right? The issuing judge must state or contain within the warrant of arrest the name of the issuing court, the date of the issuing of the warrant, the name or title of the offense, the name of defendant or description, if you don't know the name, police officer or officers, and direction to arrest and bring in. Arrest the defendant and bring him in. 120.20, warrant of arrest. When is it issuable? Okay, so lower criminal court or youth part of the superior court, there's the filing of an accusatory instrument except an STI, simplified traffic information. So filing of any accusatory instrument except simplified traffic information against the defendant who's not been arraigned. Okay, so they're trying to bring him in for arraignment. Okay, so the accusatory instrument. So that was one. And then two is basically about when it's issuable, right? Two, sufficient on its face. The accusatory instrument is sufficient on its face, so that's going to make it okay for the judge to issue a warrant of arrest. B, not sufficient on its face. Accusatory instrument is not sufficient on its face, and so it will be dismissed. I think that's supposed to be C. I put 2. Okay. Accusatory instrument is sufficient on its face. Okay, so just like the first reason, it's sufficient on its face, but the court may refuse the warrant to issue the warrant of arrest upon further examination. I'm not going to get into details of this. This is just a quick card. So the other option would be to issue a summons in lieu or in place of the warrant, or authorize the district attorney to set a date to bring the defendant in. So the option not to do the warrant of arrest and to do the summons in lieu of complaint, or just have the district attorney bring the defendant in, is because there's a feeling that the defendant will show up. So they don't really want to rush to put a warrant of arrest on the defendant. They want to give him a chance to show up. Okay, so that was 120.10 and 120.20. Okay, now we're going to do Article 120 again. This is 120.30. Okay, the warrant of arrest, by what courts issued and returnable? Warrant of arrest may be issued by lower criminal court where accusatory instrument is filed, returnable in such issuing county only. Okay, so basically the warrant of arrest where the accusatory instrument is filed is returnable only in that county where the accusatory instrument was filed. Now, when it comes to in a particular town court, okay, and the person that's filing is sought to be filing an accusatory instrument for the purpose of a warrant of arrest or a warrant of arrest, okay, they may be filed with the town of an adjoining town, so of the same county, if the town court is not available. So they're going to file the accusatory instrument or the warrant of arrest in the town court, but the town court is not available. So guess what? They may, it's okay for them to file it in the adjoining town of the same county. Okay? And lower criminal court or youth part of the superior court, any accusatory instrument filed and for the purpose of obtaining a warrant of arrest are determined by the provisions of CPL 100.55 or 100.60 of this site. And there you have 120.30. Let's go.